The Supreme Court takes up two big cases, one on the Federal Reserve's independence, whether President Trump can fire Governor Lisa Cook, and the other on the Second Amendment, whether states can preemptively prohibit concealed carry on private property, including stores and gas stations.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome, I'm Kyle Peterson with the Wall Street Journal. We're joined today by my colleagues on the Journal's opinion pages, columnist Alicia Finley and Matt Cottonetti, who writes for the WSJ's new Free Expression newsletter. Let's start with the case argued this morning. That's Trump v. Cook. Trump, of course, needing no introduction, and Lisa Cook being a member of the Federal Reserve Board of Governors appointed by President Biden in 2022. She is now fighting Trump's effort to fire her for cause. And Alicia, that is an important part of this case. The claim here is not that the president can remove any member of the Board of Governors for any reason, any disagreement, including disagreements about policy, such as what interest rates are proper at the moment. It is a for cause case. And it might be helpful just to lay out some of the background here. What is the claim that Trump is using? Maybe it's a pretext to try to remove Lisa Cook from the Fed.
Right. So I think you're 100% spot on that this was a pretext. Now, let's backtrack to what happened during the summer. And his Federal Housing Finance Agency Director, Bill Pulte, posted a criminal referral for Lisa Cook on social media. He claimed that she may have committed mortgage fraud by claiming two different homes as primary residences on mortgage applications in 2021. Now, she denied the wrongdoing and still hasn't been charged with a crime, unlike some of the other targets of Trump's lawfare. Now, he claimed that just the referral was enough cause under the Federal Reserve Act to remove her on this rationale that she, quote unquote, exhibited the sort of gross negligence in financial transactions, calls into question her competence and trustworthiness as a financial regulator. And the Justice Department argument is basically, well, we don't actually have to prove whether the allegations are true. We can fire her just for whatever reason, essentially, we claim, as long as it's not a policy disagreement. Though it's a little interesting if you read the amicus briefs in the case, is many of Mr. Trump's supporters and those advocates of a unitary theory of government or executive branch actually argue that, well, the law actually does allow him to fire Fed officials, even for policy agreements. That cause can actually be a policy dispute, such as you mentioned, differences over lower or differences over interest rates. Now, I think the Trump administration was a little leery of making that argument. It was maybe a bridge too far, I think they thought, for the justices. But their argument essentially boils down to that the president can fire a Fed officer for any reason, as long as he gives them cause and isn't a policy reason. And the judges, the Article 3 judges, have no business and have no right to adjudicate these disputes. So this is purely left up to the discretion of the executive branch. And I think that if you listen to the oral arguments on Wednesday, the justices seemed a little leery of these arguments that they were making, but there were a lot of very difficult and thorny questions posed because the law statute as written is very vague.
The Justice Department's position here is sweeping in a number of ways. So this is the table of contents in their brief, just going through their arguments. Cook has no right to a hearing. A court may not review the president's finding that sufficient cause existed to remove Cook. Regardless, the president identified cause here. Cook is not entitled to interim reinstatement. And part of what makes it hard to figure out which way the justices might be going here is that this is a case arising on the emergency docket. So unlike in appeals that go through the normal course of a writ of certiorari, there is generally then a question presented that helps narrow the focus of the briefs, the parties, the arguments, the justices on one specific question or maybe two specific questions. Whereas here it is an emergency appeal. So there are all sorts of arguments being advanced by the government. On the point about their sweeping nature, let's listen to a bit of the oral argument. This is Justice Brett Kavanaugh tangling with the Solicitor General of the United States, John Sauer.
There is a long tradition of having this exercise of monetary policy be exercised independent of executive influence, and we don't dispute that that's what Congress was doing in that statute. And again, we have not disputed the validity of the for-cause removal restriction here.
And why is that independence important in your view?
We don't dispute the importance of that for many of the reasons that their amici say, but we emphasize that there's a balance struck here. This is not a ironclad, you can never be removed. There is a cause removal authorization.
But on that, your position that there's no judicial review, no process required, no remedy available, very low bar for cause that the president alone determines, I mean, that would weaken, if not shatter, the independence of the Federal Reserve that we just discussed.
We disagree with that, and I would point to the point that the point you made, that this is a low bar for cause. In a sense, it's a very high bar. It's a very strong protection because it does protect them from the one thing that Congress was apparently most worried about, which is removal for policy disagreement.
Matt, I find myself very sympathetic with Justice Brett Kavanaugh there because the Solicitor General is saying we don't dispute that the president requires some cause to remove a Federal Reserve governor like Lisa Cook. We just think that courts can't second guess it, and this cause was enough. And remember, as Alicia lays out, this cause is basically a social media allegation by a member of the president's own administration.
Well, I think it's hard to take the Solicitor General entirely seriously when you consider that there is a major policy dispute between the executive branch and the Federal Reserve right now. The president has been more than vocal about his desire for the Federal Reserve to lower interest rates. And we know that he wants to have control as many board seats on the Federal Reserve as he can in order to achieve that policy objective. So it, I think, is not good for the government that this hearing takes place, about a week after Federal Reserve Chairman Jerome Powell announced to the world that he had received a criminal referral or a criminal subpoena, rather, from the Department of Justice relating to the renovations in the Federal Reserve building. That, too, could be seen as a pretext to get Chairman Powell out of his job before he's scheduled to depart, in any case, in May. I think when you listen to the arguments, the consensus of most legal experts is that the Trump administration is in a pretty weak position here. And because it's on the shadow docket, I wouldn't be surprised if the court simply just says, look, we're sending this back to the Court of Appeals, and Lisa Cook can remain in her job until the full panel hears the case, a case that will probably allow her to remain in there indefinitely.
Alicia, what's your read of those oral arguments this morning? And also, it might be worth underlining, too, the differences between this case and another case that is on the docket of the Supreme Court this term. That's one involving the Federal Trade Commission and other so-called independent agencies. And I think it's worth underlining because there are some significant differences. The Constitution gives the power of coining money to Congress. So there's a pretty substantial argument that at least the monetary policy functions of the Federal Reserve are not necessarily executive functions in the same way that legal conservatives have often argued the president ought to be in direct control of the FTC and the other alphabet soup of agencies around Washington.
Well, I think that's right. And that's one of the cruxes of the problem is that the Federal Reserve is in part kind of a creature of Congress. It exercises delegated powers that are purely Congress's purview, such as you mentioned, to coin money and regulate the value thereof, and to fix the standards and weights and measures. Now, the problem is that it also does exercise some executive power over banks, especially in bank supervision. It sets the prudential regulations, capital liquidity, stress tests, and has enormous executive power. And now, if you recall, actually, it's interesting, going back to the CELA law case in 2020, which was a case that regarding whether the president could fire the Consumer Financial Protection Bureau director at will. There was a for-cause removal protection inserted by Democrats in the Dodd-Frank Act to protect the director. And the court ultimately came out and said, well, no, this removal protection is illegal because the CFPB exercises broad executive power over all kinds of Americans, businesses, financial institutions. Now, that brought a kind of a testy dissent by Elena Kagan, who said, well, how different is the CFPB really than the Federal Reserve and the historical tradition of the second bank of the U.S., which was also kind of an anomaly at the time when they were created, in that they were insulated from a lot of presidential decision making. But I think that what she missed there was there actually is a very big distinction in that the Fed, to the extent the monetary policy, really is a power that was reserved for Congress, and the framers intended it that way because they didn't want the president to essentially manipulate or debase the currency like English monarchs had. So this was actually a very calculated decision. I think that in a better world and in a better Congress, what would happen is Congress would pass a law clarifying what for cause is and setting out standards or such for removal of a Federal Reserve officer, and would take the powers, the executive powers that the Federal Reserve now holds, and give that to maybe the FDIC or the OCC, which are other banking regulators. So it would be the Federal Reserve would purely be exercising monetary policy rather than some kind of executive power over the banks. Now, the problem is, of course, maybe that could eventually happen, but that's not going to happen with the Republican Congress under Donald Trump. So the court is trying to kind of decide how to rule as narrowly as possible in this case without opening up a whole can of worms that might actually let Trump, fire any other Federal Reserve governor or officer willy-nilly, or that could actually bias it or show its hand in a future case that would come before it regarding the Federal Reserve's independence.
Turning to the second big case this week, that's Walford v. Lopez. This involves 3 residents of Hawaii who say that the state has made their concealed carry permits and their Second Amendment rights essentially impossible to exercise. Despite having those concealed carry permits, Hawaii now has a law that bans carrying of any guns on private property, including retail stores and so forth, unless the carrier has the express permission of the owner or leaser or manager of the private property. And Matt, part of what I think is interesting about this is how it fits in with the Supreme Court's broader moves on the Second Amendment. So in 2022, the Supreme Court had that landmark case called Bruin. And what the justices said was that the right to keep and bear arms extends to a right to carry a handgun for self-defense outside the home. And after that, a handful of states, including Hawaii, its laws were passed here in 2023, seized on provisions of that opinion that said we are not calling into question, for example, restrictions on guns in sensitive places, and said, aha. So they started defining specific places that they would said guns would be banned, including in Hawaii, beaches, restaurants that serve any alcohol, and parks. And then a couple of them have also passed these kinds of laws saying that unless you know the mall owner and the mall owner says you can bring that firearm, or unless you see a sign that says in bold letters, firearms are welcome in this mall, there's a presumptive default ban. And I think the justices are kind of looking at this as states trying to get around what they threw down in Bruin.
If that's the way they see it, they're seeing it accurately. I mean, the timing of the state statute speaks to that, coming right after the Bruin decision. Hawaii essentially flipping the gun rights laws on their head. The presumption typically is a presumption of liberty, that you can carry unless the business or owner or the property owner gives you says explicitly you can't bring it into this business. What they did in Hawaii is turn that upside down, where you cannot carry unless you get express permission from the property owner or business owner. But that is a undue burden, in my view, on the gun owner, because one, you'd have to go into the business with your gun to ask for permission, or you go in before and you have to come back in order to carry. Or secondly, what business is going to post a sign in their front window saying "Gun owners welcome here" in indigo blue Hawaii? So I think for those reasons, you saw the justices when this case was heard earlier this week kind of point out that this is another example of a state really treating the Second Amendment, in Chief Justice Roberts' words, as a disfavored right, or in Justice Alito's words, as a second-class citizen, a gun owner. And I think that the court will pretty quickly move to correct Hawaii's mistake.
On the point about a presumption of liberty, some talk at these oral arguments about comparisons to the First Amendment. If a state can say Second Amendment rights are barred on this private property unless the owner gives explicit permission, could a similar rule, could a state do the same sort of thing for the First Amendment right to free speech? Let's listen to a bit of Justice Amy Coney Barrett raising that point.
Well, Mr. Kyle, I don't understand why you're resisting the First Amendment. Well, I do understand why you're resisting it. But let's say there's no content discrimination. It's just a ban on leafleting, and it's a ban because people don't like solicitation. So they just don't want people passing out pamphlets. It's not aimed at Jehovah's Witnesses or anything like that, like some of our old cases. Why would that fail rational basis review?
So I think it might, because as this court said in Free Speech versus Paxson, you still have to have some underlying rationality.
Yeah, people find it annoying. They don't like it. They think it affects their businesses, and people don't want to go to businesses if they're going to be accosted by pamphleteers.
But it may be a rational basis problem, but I don't think it's a First Amendment problem.
Alicia, the other thing that strikes me about this debate is the argument over the practicality. So Hawaii, in its briefs, says basically that if you are concealed carrying, if you're a permit holder, all you have to do is kind of pop your head into the store, and you need a clerk's okay to enter the store, and then you've satisfied the terms of the law. And the permit holders who are challenging this Hawaii statute say that is not how this works at all. You have to go back and read the statute. It bars them from entering any private property without express permission. And by the way, they say that also includes parking lots. And so under their reading of this law, and to my mind, it fits a kind of a plain text of what is in the Hawaii statute books at the moment. Once they've, unless you have pre-permission, unless you've gone around town and asked every place you could possibly want to go next week, can I bring my firearm in next week, and gotten that permission in advance, by the time you've parked in the gas station parking lot and popped your head in to ask the clerk, as Hawaii suggests that they do, they've already broken the law.
I think that's right. The Hawaii's being a little disingenuous, not surprisingly, about how its law actually works in practice. Now, the challengers here are correct to point out that this is a huge burden on a individual or a gun owner's right to bear arms. Now, the question here is how this all fits in with the Bruin framework that you mentioned, and that requires there to be some kind of historical precedent. I think more broadly, you see a lot of states trying to press their bounds to kind of restrict or limit gun ownership through various means, not just, Hawaii's essentially trying to wall off the Second Amendment, throughout its entire island in practice. But you also see California passing a variety of laws that try to get around the Bruin decision by restricting or imposing very burdensome background checks, limits on ammunition. There was a recent Ninth Circuit decision that involved a state law that restricted gun owners from actually carrying their guns openly in counties with more than 250,000 people. Now, interestingly enough, the Ninth Circuit panel struck down that law under Bruin. And I think that one was actually a little bit more of a tougher call But I think what's really important in this case is that the Supreme Court justices provide a little, or flesh out a little more, this Bruin standard of the historical tradition of firearm regulation, what was more common or allowed at the time. I think this Hawaii case is clearly outside of the bounds of Bruin, but I think providing a little more clarity would be helpful to states and gun owners.
It will be interesting to see how the justices apply the Bruin test in this case, because they have not had that many opportunities to do that, Matt, since handing down the Bruin decision itself in 2022. So legal nerds and myself, I include myself in that, will be watching to see how the justices handle that. But it does frame the parameters of the debate, I think, in an interesting way. So the two sides, for example, are arguing whether there are historical precedents for this kind of law in American history. And to take one example, there's a 1771 law in New Jersey that apparently banned taking a gun on lands not his own, for which the owner pays taxes unless he hath license or permission in writing from the owner. And Matt, it's interesting to watch the two sides argue about what that really means. The challengers of the Hawaii law are saying that is a poaching statute, and we know that because it bans guns. And this is an interesting line of their brief. It says, at the founding, guns were long guns or cannons, not pistols. See Noah Webster's American Dictionary of the English Language, 1828, defining gun and noting that one species of firearms, the pistol, is never called a gun. So Matt, that's a bit of a detour, a cul-de-sac, but it's interesting to see how the arguments are shaking out with respect to what the justices now say is the standard on the Second Amendment, which is this law in whatever state, is it consistent with American history and tradition of firearms regulations?
Yes, a good originalist always needs to have a copy of a first edition of Noah Webster's dictionary in order to make sure we have all the terms correct. History and tradition is something that's really kind of appeared among originalist jurisprudence basically past decade. It's associated with Justice Alito. And it's a capacious term. And I think some of the more progressive attorneys and legal experts have decided, you know what, two can play at the history and tradition game. And that led to some very interesting exchanges during the hearing this week. I mean, at one point, the justices were talking about Hawaii's contention that the black codes of the Reconstruction South, which limited gun ownership in ways similar to what Hawaii has legislated, should be part of the history and tradition here. And Justice Jackson actually agreed with Hawaii and said, well, this is history and tradition too, isn't it? But I think that the Deputy Solicitor General, Sarah Harris, put it well when she said unconstitutional laws do not count in illuminating a historical tradition, and the black codes, because they were racial classifications, are by their very nature unconstitutional. Another kind of, to me, odd historical precedent that Hawaii put forward was a proclamation by King Kamehameha III, banning weapons from the island of Hawaii when he ruled it. But I don't think such a royal proclamation would override the Constitution of the United States. And so even though you can see these kind of novel arguments, I think the justices are likely to kind of go back to the line of Second Amendment jurisprudence that they've really followed since the Heller decision, and that is giving the presumption of liberty to gun owners.
Thank you, Matt and Alicia. Thank you all for listening. You can email us at pwpodcast@wsj.com. If you like the show, please hit that subscribe button, and we'll be back tomorrow with another edition of Potomac Watch.